I'm immigration lawyer John Khosravi, and today we're talking the I-130 petition, in particular for marriage green card cases. You're a U.S. citizen or green card holder, you're applying for your spouse. You want to know a general idea of what this form is about because there's a lot of different information out there that can confuse you. We have a guide, 40 plus pages, if you go to marriageimmigrationlaw.com, that goes through the whole process. But here we're just going to focus on Form I-130 and the accompanying documents. So I'm immigration lawyer attorney John Khosravi once again. The I-130 petition is necessary when you're going to bring a family member to the United States. This could be parents, spouse, children, siblings, all those are possible, and they have different requirements for each. But again, we're going to focus just on marriage green card cases today here. And again, this is for U.S. citizen, spouse, and green card holder cases. So Form I-130 is the primary form needed for the standalone portion of the case or marriage case. Now, there's an I-130A form that's attached to that as well that you have to complete. This is for the foreign spouse's information. If the foreign spouse is not in the United States, they do not need to sign it, but the I-130 is necessary. They have new systems right now for uploading the I-130 or doing it online and uploading the I-130A actually. So that's something to be aware of. It's something you could use to make things a little bit faster to get to the government, but the old paperwork isn't as bad as well. If you're going to mail by paper, visit uscis.gov and it has the current mailing address based on where you're living. Now, speaking of where you're living, if you're not living in the United States, that could be problematic. If you're a U.S. citizen, eventually down the line, it'll be a problem for consular processing for not being domiciled in the United States, but there's time to fix that. And we're not going to go too much detail into it here. If you're a green card holder and you've had long absences and not living in the United States, that can lead to a denial of the I-130 petition, although we rarely see that actually happen in practice. So you get the I-130, you fill it out. What does it go over? It goes through your residential history, both you and your spouse, your work history, your parents' information, and a lot more little details about the marriage, dates of birth, and that kind of stuff. So you got to really fill that out. It's a lot of biographic information. And along with that, have history of your relationship together. And you have examples of documents. If you go to marriageimmigrationlaw.com and down the guide, a list of potential documents you could use. But that shows your relationship history. The more, the better. It smooths out the ride for you. But make sure to read everything, make sure it makes sense. But in addition to evidence of relationship, the primary one is, the marriage certificate. So you want to make sure that's been properly filled out and completed, signed, dated, the names are correct. Many times we have clients that don't use their full name on there, put the wrong address or information. We want it to all be consistent. So be aware of that. And if you're getting married in the United States, sometimes you'll automatically change your name at time of marriage. Be careful if you do that. It's not a bad thing necessarily, but it is a legal name change to adjust the paperwork accordingly. Now, let's say you get married in the United States and you leave and then finish the process through the embassy. The green card is going to be issued based on your passport name. So it's going to be that unless you update your passport. But if you're doing it in the United States, adjustment of status, then you will use the name based on the name change certificate. Now, I mentioned the word adjustment of status. That's the process for applying for a green card in the United States from I-485 and accompanying documents. If you are doing concurrent filing, you could submit all those together in the U.S. If you're married to a U.S. citizen, that's typically something you can do. But if you're married to a green card holder, there are delays now between the time you file the I-130, which is the date that it gets there, being called the priority date, and the date you could file the I-485 adjustment of status form, which is the actual green card application. They're separated. To see what dates are currently being approved, check out the, when I say approved, it means they're looking at because approval dates are all over the place. But go check out a thing called the USCI's Visa Bulletin to see when you could submit the I-485. As well as what dates they're reviewing right now. It'll have links to the Department of State's Visa Bulletin as well. Kind of confusing, but we got separate videos on that could help you as well. So you want to get all the documents together, marriage records, divorce records, and be mindful if you're doing a proxy marriage or you haven't seen each other, that's going to be a problem for the case. If you had previous divorces, you have to have those records ready, and the divorce has to be finalized before a new marriage happens. If you're remarrying a spouse, that could be a little bit complicated. If you obtain your green card based on a marriage, now that you have a green card, you're applying for someone else, that could be an issue. So you got to be careful of all this stuff. And on the petitioner side, the petitioner is the U.S. person, citizen or green card holder filing the case. You have to not have certain crimes related to children because that can prevent you from making this petition under something called the Adam Walsh Act. Now, the foreign spouse is called the beneficiary in this context, but applicant as well. So be mindful of these different terminology name uses that do pop up. So I might have mentioned before, but the form I-130A is what we use right now. Previously, like 5 or 6 years ago, the form I would be completed with the G325A. So if you see or hear I'm talking about the G325A, please note that it's not used for this kind of case anymore. So you don't need to get that and get into it. It shouldn't be a problem. The remaining things are, is there going to be an interview? If you're doing the eventual embassy appointment, the green card through the embassy, there is an interview there. If you're doing adjustment of status in the United States, while I'm recording this in 2024, most cases have been waived for the interview because they're so backed up, but that could change. So just be mindful of that. With regards to the last issue I want to talk about is children. If you're a U.S. citizen and you're married and you want to file for your spouse to come to the United States, you just need one I-130. But if you have kids and you want to apply for them too, each child needs their own independent form I-130. So be very careful of that. However, if you're a green card holder and you apply for your spouse, the minor children will be part of that simple single I-130 petition. When they go to the embassy, they each have to file their different applications. There'll be separate fees for each of them. But for the I-130 petition, that's one. Now, if you're a green card holder, and while the case is pending you become a citizen, if you had kids in that case, they get cut out. So make sure they haven't aged out, not minors anymore. It can be problematic. You need to submit new I-130s for them. So don't become a citizen or apply for citizenship in this context until you know exactly what's going on with your case. And how long do these I-130 petitions take? They go all over the place. We just got one approved in 3 months, another in 15 months. But I would say right now, 2024 average is around 12 months for a U.S. citizen spouse case. If you are married a green card holder, that kind of I-130 petition, those could take sometimes, 1, 2 years, maybe even longer, because a huge backlog was created in this visa bulletin category, the preference category. F2A is what it's called, like taking 3 to 5 years. So they put it on the back burner and they're approving these slower. So if your case is I-130 is taking longer because you're married to a green card holder, it's not that abnormal right now, 2024, to deal with that. Now, I keep mentioning 2024 on purpose because it's election year, and next year we don't know who the president's going to be, and that can have a big effect on what happens. Now, the I-130 is just primarily focused on showing the relationship is real. Whether the person can get the green card is a whole nother story about inadmissibility in the I-485 adjustment of status application or consular processing. We'll have separate videos on that, but check it all out at marriageimmigrationlaw.com. Free PDF guide, 40 plus pages that really breaks down the process with videos for each section and a guide, a chart that really fleshes it out for you. So I hope that information helps, and I hope you contact us so we can help you as well.